Well, hello everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. I am a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope today is the day I earn that subscription. For today's story, we are going to be doing a full reading of this motion, or this order rather, as it relates to an injunction in Tennessee from the Court of Appeals for the Sixth Circuit, which governs federal law as it relates to appeals for Tennessee. Tennessee passed a law dealing with transgender surgeries as it relates to minors and said, maybe the sterilization of minors is bad. Maybe hacking off their organs is bad. Maybe we shouldn't do that. Maybe injecting them with all these hormones and puberty blockers, the same drugs that are often used, for example, for people who have committed certain offenses to chemically prevent them from committing further offenses, and we give that to the children. Maybe we should stop doing that. So Tennessee is like, that's bad. And then a whole bunch of people were like, no, we'd really like to hack off bits and inject them with the drugs and prevent the puberty and give them the same medications that we give to convicted child abusers, because that sounds like fun and we'd like to give that to our children. So Tennessee and these people are apparently having a fight about it, and there was an injunction heard in the lower court, and injunctions can be appealed to the Court of Appeals, and that's what we have. We have a decision on the injunction. So we're going to read this and try to understand all this. Let's get started with this. All right, so this is from Sutton, who apparently is the chief judge for the circuit. Every circuit has a chief judge who is there mostly as an administrative role, kind of like a chief justice in that respect, I suppose. Their vote is exactly the same as anyone else's. It is just that they have some additional administrative responsibilities. So they're apparently the chief judge in the Sixth Circuit. Fine. Tennessee enacted a law that prohibits healthcare providers from performing, let's call it gender affirming surgeries, or maybe we can call it, mutilation of genitals, which, sounds bad, or hormone therapies, or puberty blockers, or other things which have potentially lifelong and potentially irreversible consequences, and administering these hormones or puberty blockers to transgender minors, people who are under the age of 18 and, may not be fully understanding exactly what they're doing. And we don't typically allow them to just willy nilly consent to certain things. And we think that this is bad as it relates to the practice of medicine, says Tennessee. After determining the law likely violated the equal protection and due process clauses, the district court facially enjoined the law's enforcement as to hormones and puberty blockers and applied injunctions to all people in the state. All right, so the word facial here is doing some legal lifting. When it comes to laws, we can look at them in facial challenges or as applied challenges. So when we're trying to challenge a law because we think it's illegal, we can challenge it either as applied, it's illegal as to me, or facially in general. Facial challenges are obviously a lot harder, because in a facial challenge, you basically have to prove that the law has no effect, it's invalid as to everybody, right? As applied is easier. It's like invalid as to me, but facially it's invalid for everyone is harder. So the district court said this is invalid as to everybody, validate it on its face. And as a result of that, applied it to everyone in the state because it would be invalid on its face. So the law protecting the minors, the law preventing the transgender hacking off bits and puberty blockers and gender affirming hormones, that law is a bad law, says district court. We're not going to let that go forward, and we're not going to let forward statewide. Tennessee moved for a stay because Tennessee is likely to succeed. We grant the stay. So they're like, hey, Sixth Circuit, can you prevent this from going into effect? The Sixth Circuit's like, yep, sure can. So the decision from the district court that says this law is invalid is stayed. So the law remains valid for the moment. Well, I guess strictly speaking, technically, the law is still invalid. The fact that it's invalid is paused. So it's valid. It's legally confusing if we want to be precise. Let's press on. In March of 2023, Tennessee enacted the Prohibition on Medical Procedures Performed on Minors Related to Sexual Identity Act. It was scheduled to go into effect on July the 1st and is now in effect, seeking to prevent minors from physical and emotional harm. the legislature identified several concerns about recent treatments being offered by medical professions for children with gender dysphoria. Yeah. It was a concern that some treatments for gender dysphoria can lead to a minor being irreversibly sterile, having increased risk of disease and illness, or suffering adverse, sometimes fatal psychological consequences. Yeah, so the treatment may be as worse as the quote unquote disease because we are treating these children ostensibly because of concerns about their psychological welfare. But the treatment itself can have severe psychological consequences because the children may not fully understand exactly what they're doing, and their conviction at 12 may not necessarily be their conviction at 18. So some of these people have had to reverse themselves. And some people have talked about it, not that you'd hear it from any sort of mainstream publication, but if you go looking, it's not too hard to find people who have gone through transgender surgeries as minors and now are like, I really regret it and I was pressured into it and now these things are irreversible. There's nothing I can do about it. So the treatment is barbaric. So we shouldn't allow it. It was concerning the long-term costs of these treatments remain unknown, which, yeah, because we haven't been doing this as a society like ever. So we don't really have any good long-term data because there is no long-term. We've been trying to apparently hack the bits off of children, only recently. We used to think this was bad, so we didn't do it. And now we think it's good, but we don't know what the long term is going to be because how would you know? Uh-huh. So it was concerned the long term costs of these remain unknown and outweigh any near term benefits because they're experimental nature and not supported by high quality long term medical studies. And noted that other helpful, less risky, and non irreversible treatments remain available. So the state of Tennessee, doing what states do in terms of the regulation of medicine, which is a state level concern, says, we do not think that this is valid medicine. I know there's some doctors out there who seem to think this is valid medicine, but these medical professionals do have to get a license to practice medicine from the state, as one does. So are there some doctors out here who think this is valid medicine? Yeah, but the state of Tennessee is like, we don't think it's valid medicine. And it's regulated by the state, right? And we've also seen this the other way around, by the way, for whatever it's worth. For example, in California notably made it illegal to do for psychologists or psychiatrists to provide gender transitioning, or what would you say, the other way around, to do to try to convince a child who thinks that they're gay that they're actually straight, to try to do gender or sex confirming therapy. So California has banned this the other way around by saying, okay, if a child comes to you and says, I'm gay or I'm transgender, it is illegal in California for the therapist to be like, no, you're not. You're simply confused and don't know what you're talking about. And I'm going to help you. I'm going to help you learn how to be straight. The efficacy of these treatments, of course, is debatable. But whatever the efficacy is, California's like made it illegal. But it's kind of the same problem in reverse, right? Are there some doctors in California who might be able to think that they could provide therapy to gay or transgender people to convince them or persuade them or churn them straight? Is that a thing that some doctors believe they could do? Probably. As California is a big state, there's probably some doctors who believe that they could do it. Perhaps not completely, but perhaps partially. And California's over here like, nope, we're not going to allow that as the practice of medicine. And Tennessee's basically the other way around. It's like, yeah, we're not going to do that. Thank you, Jules Buddha, as always, for your gift memberships. They are, as always, extensively appreciated. Yeah, conversion therapy was the word I was looking for. Thank you. I couldn't quite come up with it, but yeah, the chat is there. Conversion therapy was the term I was looking for. So we ban therapy to try to convert the gay or the transgender into straight people, and Tennessee's kind of gone the other way around. Like, we ban the therapy to convert the males into females. So yeah. And we also think as a state that other treatments are available that are helpful and also less risky and non-reversible, so, or that they are reversible, so we can do those instead. These findings convinced the legislature to ban certain medical treatments for minors with the gender dysphoria. A medical provider may not administer or offer to administer a medical procedure for a minor for the purpose of enabling a minor to identify with or live as a purported identity inconsistent with the minor's sex, or treating purportedly discomfort or distress from discordance between the minor's sex and asserted identity. Prohibited procedures include surgically removing, modifying, altering, or entering into tissues, cavities, or organs, and prescribing, administering, or dispensing any puberty blocker or hormone. Now, this is all, again, for, by the way, just to make it clear to the people in the back, this is all for the purpose of enabling the minor to identify with, live as a purported identity inconsistent with their sex. So, can you administer these treatments for other reasons? Yes, you can. And there might be valid medical reasons to do these treatments. Is there a reason medically? I'm not a doctor. I don't know, but I'm just going to go out on a lark and assume that there are other reasons that you might want to prescribe a puberty blocker or hormone other than for the purpose of, trying to transition them. Maybe some people don't have enough natural hormone and we need to give them boosters. Maybe there's a person out there, maybe there's men out there who produce no testosterone. I don't know. Is that a thing? I'm not sure. Maybe. And we're going to give them testosterone artificially because, their body doesn't produce it naturally. They never go through puberty because their body produces no testosterone. Is that a thing? I don't know. But if it is a thing, we could do that. So we could also, of course, remove or alter tissues or cavities or organs for other medical necessity. So, if they have cancer or something, we can remove the cancerous bit because, that would be good. But we can't do it for these reasons. So we're just preventing the barbaric practice of medicine. Okay. The Act contains two exceptions. It permits the use of these procedures to treat congenital defects, precocious puberty, disease, or physical injury. So we can do it to treat defects, precocious puberty, where puberty onsets too early. So that would be, where, maybe there's an 8-year-old going through puberty and we want to delay it till they're like, 12 or something. We can do that. Or, of course, physical injury. And it has a continuing care exception until 2024, which permits healthcare providers to continue administering the treatments that began before the Act date. So anyone who's already undergoing these treatments is grandfathered in because, well, we don't want to get into the issue of, you know, deprivation of rights or something. Yeah. Yeah. Catherine points out that there are people that are not born biologically male or biologically female. Yes, that's true. I was contemplating a person who was born biologically male but does not produce testosterone, which was a slightly more specific thing. But yes, there's obviously people who are, because I was trying to make the example cleaner. Right, that's one of the reasons I was trying to make the example cleaner. And if you get into the intersex people, it's less clean of an example because you get into debates about what their hormones are supposed to be in sort of a natural sense. So I tried to make the example clear, but like, let's suppose that there is a biological male but doesn't produce testosterone. I'm like, is that a thing? I'm like, maybe. But if it was a thing, that we could give them testosterone because they should be producing it, but they're not. So that was my hypothetical. So yeah. Also, I'm not a doctor. So if that example is not a thing, I'm not a doctor. I just made up an example that would try to illustrate the point. Yeah. The act authorizes the Tennessee Attorney General to enforce these prohibitions. It permits the relevant state agencies to impose professional discipline on healthcare providers that violate the act, and it creates a private right of action enabling an injured minor or non-consenting parent to sue the healthcare provider. Based. These transgender minors, their parents, and doctors sued several state officials, claiming the act violates the United States Constitutions of due process and equal protection. Probably not. When the Supreme Court has previously ruled that medical, and it came up in the context of abortion, where it came up, that medical aspects that only impact one's sex are not discrimination on the basis of sex. So, banning abortion is not discrimination on the basis of sex. And now, it is true that only women can give birth and get pregnant. I know this is controversial information to the left, but it's true. Only the women can get pregnant. But despite that, the fact it is only women, the banning of abortion is not sex based in the view of the Supreme Court, because we're not doing it because of their sex. We're doing it because, baby growing that has independent life and independent value, independent of the woman. And that value also has to be measured and considered as part of the analysis. So, for similar reasons, I don't think that this violates the equal protection. Are we discriminating on the basis? Is the treatment relating to sex? Yes. Is it discrimination on the basis of sex? Not clear. Not clear that it is, given the Supreme Court's distinctions. So, and when it comes to medicine in particular, right? Medicine, as you would expect, has slightly more nuance, because unbelievably, men and women are biologically different. I know. It is a shocker to me too. It is true. So the practice of medicine is, and probably should be, somewhat tailored to these differences. I've heard women complain that it's not tailored enough, because the practice of medicine was often based on the assumption of male. I don't know the degree to which that's true. I'm not a medical historian, but I've heard it before. So if that is true, we should make sure that medicine is even more tailored to the differences in sex. So tailoring medicine to sex is not sex discrimination. It's biological reality. And medicine is a biological treatment. So there's that. I can't believe I have to explain it, but here we are. Yeah. Yeah. I agree with you, Kestrel, that, well, intersex is a medical condition. I understand. Yes. I might have psychological impacts. Yes. But let's for the moment just deal with XX and XY. Non-XX and non-XY are an incredibly small part of the population. Uh, it's been a while since I looked it up, but I think it's something like 1 out of 1,000. Hold on. Let me look it up. 0.5%. So I was off by a little bit. Oh, no, no, no. And then there's a National Institute of Health. Okay. So here's National Institute of Health. Okay. There's a paper. Anne Fasto Sterling's suggestion that prevalence of intersex might be as high as 1.7 has attracted wide attention in both scholarly press and popular media. Many reviewers are not aware this figure includes conditions which most clinicians do not recognize as intersex, such as Klinefelter syndrome, Turner syndrome, and late onset adrenal hyperplasia. If the term intersex is to retain any meaning, the term should be restricted to those conditions in which chromosomal sex is inconsistent with phenotypic sex, or which the phenotype is not classifiable as either male or female. Applying this more precise definition, the true prevalence of intersex is seen to be around 0.02%. So that would be 2 out of 10,000 or 1 out of 5,000. So, you know, we'll save the 1 out of 5,000 case for another day and just deal with the XX and XY for the moment. All right, great. Yeah. Okay. The three transgender minors, their parents, and doctors sued state officials. The plaintiffs challenged the action's prohibitions on hormone therapy and surgical prohibitions, but they did not challenge the private right of action. They moved for preliminary injunction to prevent those features of the act from taking effect. On June 28th, the district court granted the motion in part. It concluded that challengers lack standing to contest the ban on surgeries, but could challenge the ban on hormones and puberty blockers. As to due process, the court found the act infringes on a parent's fundamental right to direct medical care of their children. but the state has the ability to regulate what the practice of medicine looks like. So, okay. As to equal protection, the court reasoned the act impermissibly discriminates on the basis of sex and that transgender persons constitute a quasi suspect class, and the state could not satisfy the necessary justification that came with the designation. Eh. The district court concluded that the act was facially unconstitutional, with the exception of the surgery and private enforcement provisions, and issued a statewide injunction. Tennessee appealed. It unsuccessfully sought to stay in the district court. So the district court's like, no, I'm not going to put a restriction on my order. And so they appealed to the Sixth Circuit for an emergency stay. A request for a stay pending appeal prompts for question. And then we look at the standard rule. Is applicant likely to succeed? Will applicants be irreparably injured? Will stay injure other parties? Does public interest favor a stay? This is the same four-part standard for injunctions everywhere. Sometimes slightly worded differently depending on exactly which court case we're citing, but it's the exact same four-part test. It's always been, possibly in slightly different words, but this should look very familiar. As is often the case in a constitutional challenge, the likelihood of success inquiry is first among equals. In this case, is the positive. While I assess the district court's ultimate decision, where to grant the preliminary injunction for abuse of discretion, we assess the legal determination, including likelihood of success, with fresh eyes. There are two merit-related problems with district order. One relates to its scope. The other relates to the assessment of plaintiff's chances in challenging the act. The district court rested its preliminary injunction on facial invalidation of the act as opposed to as applied invalidation, and assumed the authority to issue a statewide injunction. We doubt each premise. The challengers claim the law facially violates the Constitution, but litigants raising a facial challenge to a statute normally must establish that no set of circumstances exist under which the state statute would be valid. That's basically correct. Maybe not quite no set, but that whatever set would exist is, so small as to be de minimis or irrelevant. So, yeah, when you're trying to challenge a statute facially, you have to basically prove that it's invalid in essentially all aspects. Maybe there's some small caveat out there somewhere, but, that's essentially invalid through and through. This is a strict standard we have no authority to dilute. The district court questioned where the test applied and declined to engage with Tennessee's argument it could lawfully apply the act in some settings. But it's not for lower court judges to depart from the case law, meaning that plaintiffs must show no set of valid applications of the law before we declare it invalid in all applications. Or whatever valid set is there is perhaps so minimal as to not matter. Turning to the nature of the injunction, district court should not grant relief that extends further than necessary to prevent the injury. The court's injunction prohibits Tennessee from enforcing the law against the 9 challengers in this case and against the other 7 million residents of the volunteer state. But absent a properly certified class action, why would the 9 residents represent 7 million? Does the nature of federal judicial power, or for that matter, Article 3, permit such sweeping relief? A rising chorus suggests not. Well, this is getting to this idea of these universal injunctions. And there is a lot of question on this, right? So even, and this case is even statewide, but even this judge is like, these injunctions, which are having far reach beyond the plaintiffs, are something of concern. And this is more of a concern when we're thinking of a court applying it outside the boundaries of their jurisdiction. But even here, the court's like, this sweeping problem is a problem, Again, apparently the rate of the intersex is about 1 in 5,000. So given that more than 5,000 babies are born every day, yes, it is true, infants are born every day that are intersex, because that would be the nature of large numbers. Yeah, there's probably quite a few who are born every single day, but can we please stick to the 99.99 8% that are not. That would be helpful. Article 3 confines to the judicial power to cases and controversies. Federal courts may not issue advisory opinions or address statutes in the abstract. They instead must operate in a party specific and injury focused manner. A court order that goes beyond injuries of a particular plaintiff to enjoin governmental action against non parties exceeds the norms of governmental power. I was just quoting the Matova. I was just quoting the number from this article from the National Institute of Health. I was just quoting the number from Leonard Sachs, who said the true prevalence of intersex is about 0.018, which means that it's 99.992. Yeah. So I was just quoting Leonard Sachs. So apparently it is true. Unless you know more than Leonard Sachs. I'm not a doctor, but I was just quoting his number. Um, Even if courts may in some instances wield such power, the district court likely abuses discretion by deploying them here. In particular, it did not offer any meaningful reason for granting such relief, creating considerable doubt about the surviving of this overriding decision on appeal. Oh, it should be 8-2, shouldn't it? Because it's 1. 99.982, not 99.992. Forgot to take off 1. Sorry, that was my error in math. 99.982%. Apologize for the 1 out of 10,000 mistake there. That was, yeah. The challengers are also unlikely to prevail on their due process and equal protection claims. Start with several considerations that apply to both claims. First, the challengers do not argue their original fixed meaning of either due process or equal protection guarantee covers the claims. That prompts the question of whether the people of this country ever agreed to remove debates of this sort about the use of new drug treatments on minors from conventional plays for dealing with new norms, new drugs, and new technologies. The democratic process. Life tenured federal judges should be wary of removing a vexing and novel topic of medical debate from the ebbs and flow of democracy by constructing a largely unamendable federal constitution to apply the field. Respect, especially in the practice of medicine in particular, because the practice of medicine in particular has been committed to states sort of from the beginning. It's always been a state level concern. Um, so at least, so there in particular in the field of medicine, I think, the federal government needs to be cautious because it gets into the roles of states. Yeah. Also, for what it's worth, I don't I very much dislike, people who try to use very very rare exceptions to try to like completely break the rule. And you see this happen in abortion debates sometimes, which is also annoying. For example, a person who's pro-choice might say, "Okay, I believe that abortion should be wrong." And the person who's against them, this interlocutor who's opposing them, might say something like, "Well, how about the case of incest?" And the you're like, "Okay, like that is less than 1% of the time that we're talking about those kinds of things. So, can we first agree on the main principle before we talk about the exceptions?" Right? You want to talk about the exceptions. We can talk about the exceptions, but can we first agree on the rule? And then we can talk about the exceptions. Why are we immediately going to exceptions? Why are you trying to use the exceptions to completely bust open the rule? 99% of the abortions are immoral. Then we'll debate the remaining 1%. But if we don't agree as to the 99%, there's really no point in us talking about the 1%. Right? There's no point in talking about the marginal case if we can't agree on the normal case. So, yeah. So it's like the same thing in transgender issues. It's like, are there people that are born intersex? Yes. But what about the intersex is a really bad kind of argument, because it's like, okay, can we first agree that it's wrong for the non-intersexed? Can we agree to as to that? If we can agree as to that much, then we can talk about the intersex people. But if we can't agree as to the rule, there's no point about talking about the exception. Yeah. Second, while the challengers do invoke constitutional precedents of the Supreme Court and our court in bringing the lawsuit, not one of them resolves the claim. In each instance, they seek to extend the constitutional guarantees to new territory. There's nothing wrong with that, to be sure, but it does suggest the key premise of a preliminary injunction. Likelihood of success on the merits is missing. The burden of establishing an imperative for constitutionally new areas of American life is not and should not be a light one, particularly where states are currently engaged in serious, thoughtful debate about the issue. Third, the states are indeed engaged on these issues, as recent proliferation of legislative activity shows. Yeah, I mean, that much can't be denied. I mean, even the opposition to this order wouldn't deny that the legislatures of various states are taking action on this issue. They don't approve of that action, but they won't deny the actions occurring. And then they cite some examples. Leaving the preliminary injunction in place starts to grind these all over the map gears to a halt. Given the high stakes of the nascent policy deliberations, the long term health of children facing gender dysphoria, sound government usually benefits from more rather than less debate, from more rather than less input, from more rather than less consideration of fair minded policy. To permit legislatures on one side of the debate to have their say, while silencing legislatures on the other side of the debate under the US Constitution, does not further these goals. Fair, respect, appreciated. Thank you, by the way, for the 300 of you who are here, by the way. Just want to take a moment while we're, here and 30 minutes into it, getting now that we're warmed up, let's take a moment to say thank you to the 300 of you who are currently here, 300 of you who are interested in this deep legal dive as we try to go through this and try to understand what the court is saying and why it's saying. I like this stuff. I hope you like this stuff too. And I hope that I make it enjoyable and understandable, and make it more comprehensible about the underlying philosophies of some things and why things are the way they are. This is a lot of fun. Alan Parker gifted some gift memberships. Thank you, Alan Parker. As always, for the gift memberships, Alan Parker and Jules Buddha, who did donate earlier, have been reliable donators to the channel as of late. And you can be like them too. You can be like them too. If you hit the little dollar sign thing that is by your messages for chat, if you're not on mobile, I think if you're on mobile, maybe not so much, but if you're not on mobile, you can gift memberships, and you can also hit the beautiful join button. And if you don't see the beautiful join button, there's a link that comes by from time to time that gives you a link for mobile so that you can get there directly. And this channel is very much supported by viewers like you. It is because of you guys that I'm able to keep going and all this stuff. And by the way, as well, thank you for all the people encouraging me, as always, in my continuing workout journey. It's a lot. We do what we can. I appreciate everyone who's here. Grant asks if I consider just being outraged instead of doing complete complex legal analysis. No, I can do both at the same time. I can be both outraged and do complex legal analysis, as I've done before, as I do every time when I talk about Chevron or Wickard. It's like, yes, I can do complex legal analysis and also be outraged because this is bullshit, you know? But it's like I have to understand the thing before I can criticize the thing, right? It's like, how about I listen, understand, and then disagree? Well, you know, how about I make sure I fully understand your position and then be like, nah, I don't think that's right. Here's why. Let me provide an alternative rationale. That's one of the things I really love about the Supreme Court in particular, because it's thinking. It's thinking out loud. It's thinking in written form. And so you can literally trace someone's thoughts, and you can be like, okay, you made an error here, you made an error here, this doesn't quite work, this doesn't quite flow, here's a mistake, I disagree with this, here's this error, blah, 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 blah. And you can, or it persuades you because it's like it makes a lot, it makes an argument, you're like, oh yeah, that argument's right. Thank you very much, Bry K, for the super chats. Yeah. And I like explaining it. John Doe became a member. Thank you for hitting that beautiful join button. Karen gifts $20 as well. Yeah. And then you can sort of think, I like it because you also get to see where the problem is. You know, if you have a well constructed argument, you can see in your if you have a well constructed argument, you can see where in the chain of logic the problem is, which is something that's often missed in debate. I find abortion's another good example. I've found a lot of conversations on abortion to be frustrating because people kind of want to go to the end immediately, and they don't want to like go higher up in the reasoning where it's more productive. So, you know, if you and I were going to have a debate on abortion, and I'm being like, you know, I think pro life is good. Well, I support pro choice. You know, do you like killing babies? You know, are you a misogynist who hates women? This is not particularly helpful, right? We're having a discussion at the very end of a logic process, hopefully a logic process or emotional process or some process that has brought us to this conclusion. And without understanding the process, without understanding the chain that got us there, we can't figure out where the mistake or error was. So if we actually had a discussion, one of the things I try to figure out in the discussion is where is our point of disagreement so that I can have the conversation at the right level of the disagreement. And you know, if we disagree on first principles, then there's might probably nowhere left to go. But then at least we know the problem is at first principles. So, anyways, that many members of the medical community support plaintiffs is surely relevant, but it's not dispositive for the same reason we would not defer to consensus among economics about proper incentives for interpreting the impact of contracts or takings clause. And again, yes, there are medical professionals who support this. There are medical professionals who probably support conversion therapy. I'm sure. You know, I'm sure there are, but it's illegal. So the fact that you can find doctors who support it doesn't necessarily mean it's within the practice of medicine or should be in the practice of medicine, depending on, you know, yeah. Catherine Fraser says, in my mind, the abortion debate narrows down to her body, her choice. Yeah, that doesn't really help because you assume the premise in the abortion debate. You assume her body, which is not a gimme. And so you're back. If you can say her body, her choice, but that doesn't really resolve the issue. It doesn't resolve the issue for the pro-choice side or for the pro-life side, because the pro-life side would be like, yeah, her body, her choice, implicitly not her body, not her choice, and now we're back off to the races. Anyways, at all events, the medical and regulatory authorities are not of one mind about using hormonal therapy to treat gender dysphoria. Else, the FDA would now have approved the use of the drug for these purposes, which incidentally they have not. These drugs have not been approved for this purpose. This is all off-label care, which is legal, but you know, it's just not what it was designed for. This has not happened, however, giving us considerable pause about constitutionalizing an answer they have not given, or best we can tell, even finally studied. And then also, this is very true. Max points out the my body, my choice argument went out the window when the instant they started mandating vaccines. Yeah, that's fair. That's very fair. Do you really believe in my body, my choice or not? Yeah. But you have to take the shot. Why? Well, because your failure to take the shot impacts other people. So you have to take the shot because other people are being impacted. And then the pro-life people are over here like, so yeah. Due process. The challengers argue the act violates due process right to control medical care of children. No state, the 14th Amendment says, shall deprive any person of life, liberty, or property without due process of law. The provision over time has come to secure more than procedural right. It also includes substantive protections. It does. It shouldn't, but it does. Right? We should be doing all this under privileges or immunities clause, but we're doing it under substantive due process because we made a mistake at this point about 100 years ago, and it would be really, really annoying to undo it. So we're stuck with this now. Courts identify such rights by looking for norms that are fundamental or deeply rooted in this nation's tradition or in history. Experience has shown that substantive due process is a treacherous field. Increasingly appreciative of danger, the federal courts have come to be ever more reluctant to expand the concept of substantive due process. Yeah. Parents, it's true, have a substantive due process right to make decisions concerning the care, custody, and control of their children. But the Supreme Court case recognizing this right confines it to narrow fields such as education and visitation. No Supreme Court extends to a general right to receive new medical or experimental drug treatments. In view of high stakes of constitutionalizing areas of public policy, any such right must be defined with care. The challenge is not shown to right to new medical treatments is deeply rooted in our histories and tradition. I do love the fact that we're looking for deeply rooted in our histories and tradition, right? When it comes to substantive due process, when it comes to constitutional rights, right? We're looking for deeply rooted in our history and tradition. Yeah, that's what we need for, right? So this is basically all, by the way, of the Ninth Amendment, right? Because the Ninth Amendment says, well, there are other rights that we haven't told you about. Well, what are they, right? So this is how we deal with this, deeply rooted in our history and tradition. So if we're going to recognize a new substantive right as a constitutional matter, we're looking for things that have, as deep a root. For example, marriage maybe would be a good example, because no part of the Constitution talks about it. But the idea of marriage is so deeply baked into our ethos that it is a right to get married, which incidentally is why when you're talking about gay marriage, right, you're like, okay, there's a right to get married. And then you have to come up with a reason not to allow the gay marriage, a legal reason, which incidentally I wasn't able to do. I couldn't do it. Couldn't think of one. So, and neither could the Supreme Court. So, yeah. So that's, when you try to follow the logic all the way through, as one does, right? When you try to follow the logic all the way through. So, right. So, you can do this easily enough, on back of the envelope analysis. It's like premise. Premise is there's a fundamental right to get married. Even if you want to say there's a fundamental right for straight people to get married, fine. There's a fundamental right for men and women to get married. Okay, fine. There's this thing called the Equal Protection Clause that says that equal protection for citizens of the United States. Okay, so why are we saying that men can't marry men? What is the rationale? And like in if you need at least a rational basis, at least you might need more than that, but you need at least rational basis because the government can't act arbitrarily. The government can't act capriciously. It has to act with at least a reason. Any reason will do. And the problem is none of the reasons work. None of the reasons work when you actually try to apply it. It's like, okay, we need marriage between one man and one woman because only men and women can have children. Okay, are you making any attempt at all to see that only men and women who want to have children or can have children get married? Right? Would you let two 80-year-olds get married? You would? You'd let two 80-year-olds get married? Those 80-year-olds can't get those 80-year-olds can't have kids. So what are we talking about? So are those marriages invalid? Is it marriage between the two 80-year-olds invalid? No? Okay, so it must be something other than having kids. So your reason falls apart. And you keep going down the line and nothing works. And nothing works. So yeah. And that's all, of course, assuming rational basis. If you up it because it's a sex-based discrimination, then you would need intermediate scrutiny, but you can't even make rational basis scrutiny, so things are not looking good for you. Constitutionalizing new parent rights in the context of new medical treatments is no easy task. On the one side of the ledger, parents can generally be expected to know what's best for their children. On the other side of the ledger, state governments have an abiding interest in preserving the welfare of children and protecting the integrity and ethics of the medical profession. These interests give states broad power, even broad power that limits parental freedom, particularly in areas of new treatment. We doubt, for example, There are many regulatory agencies in the world that, without satisfactory long term testing, would delegate to parents and a doctor exclusive authority to decide whether to permit a potentially irreversible drug treatment. So, yeah, as we're looking like kind of in the entire world, basically no one in the world does this because it would be really, really dumb. More generally, state legislatures play a critical role in regulating health and welfare, and their efforts are usually entitled to a strong presumption of validity. As a result, federal courts must be vigilant not to substitute their views for those of the legislature. Judicial deference is especially appropriate where medical and scientific uncertainty exists. That too, in particular, judges are not typically doctors. There's probably a few out there who have an MD too, but not a lot of them. Judges are not doctors. Judges are not scientists, and so they need to defer to experts. Because they need to stay in their lane, as one would appreciate. They need to get educated by experts so that they can make a good judicial decision. In this respect, consider the work of the FDA under a highly reticulated process that requires reticulated. Hmm. Under a highly reticulated process that requires considerable long-range testing, the FDA determines when new drugs are safe for public use, including by minors, and when new drugs are safe for purposes but not others. In making those decisions and occasionally frustrating those who would like to have access to new drugs sooner, the Constitution rarely has a say over the FDA's work. There's no constitutional right to use a new drug the FDA has determined safe, unsafe, or ineffective. This is true. This has come up in people who want access to experimental drugs for treatment of particular diseases that they are dying from and will die from. And it's like, well, I'm already dying. Might as well take my chances with the medical drugs. And the FDA is over here like, well, I understand that and all, but if we let that as a policy, that would potentially let drug companies take advantage of people who are particularly desperate and lead to a bunch of negative consequences. Because it's like, okay, I understand that there's this experimental drug. I understand you're dying. I understand you want access to it. But if we said that you have access to it, everyone has access to it. And what's the harm with that? The harm with that is that suddenly all these drug companies can market what might very well be snake oil at exorbitant prices to people who are incredibly desperate for it because they're going to die. And, we're doing medical experimentation now on the incredibly vulnerable. So that's concerning. So there's some counter considerations here that we have to look at. Today's case has many parallels to that one. Gender affirming procedures often employ FDA approved drugs for non approved off label uses. Tennessee has decided that such an off label use in this area presents unacceptable dangers. Many medical professionals and many medical organizations may disagree, but the Constitution does not require Tennessee to view these treatments the same way the majority of experts or to allow drugs for all uses simply because the FDA has allowed them for some. It is well within a state's police power, and by the term police power here, we, as always, do not mean police in terms of the people who ride around in cop cars and arrest you. We don't mean police in that sense. When we say police power, it has a special meaning. It is the general power to do stuff. It is the general power of the government to act. Police power is the general power of the government to act. So the federal government does not have police power. It might have law enforcement, but it doesn't have police power because the federal government does not have general power to act because it's a government of limited power because of the Constitution. So the term police power here is basically the power of the government to generally act. So it's within the police power to ban off-label use of certain drugs. At the same time, it's difficult to maintain the medical community is of one mind about the use of the therapy when the FDA is not prepared to put its credibility and careful testing protocols behind the use. Nice. A different case does not alter this conclusion. A Michigan health program had collected blood samples from newborns and stored the samples for further uses. This program, we held, violated non consenting parents' right to make decisions concerning the medical care of their children. That case differs from this in at least two ways. Unlike the Michigan program, the Tennessee Act rests on legislative judgment that will protect the health of a child. And the Michigan program compelled care, while the Tennessee law prohibits care. Although some individuals might have a constitutional right to refuse treatment, the Supreme Court has not handled affirmative requests for treatment in the same way. Most circuits have drawn the line, rejecting arguments the Constitution provides an affirmative right of access to particular medical treatments reasonably prohibited by the government. A different case illustrates the point. Harold Glucksberg claimed that the Washington state ban on physician assisted suicide violated his due process rights. The court held the Constitution did not bestow an affirmative right to physician assistants in committing a suicide. The state could prohibit individuals from receiving care they wanted and their physicians wished to provide, all despite personal and profound liberty interests at stake. And so, as in this case, so in this one, indeed more so in this one, there's a little reason to think that parents' right to make decisions for a child sweeps more broadly than an adult's rights to make decisions for themselves. All told, plaintiffs' efforts to expand our substitute process to this area are unlikely to succeed. The Sixth Circuit over here chiding the district court in Tennessee. I don't think the district court in Tennessee is going to get the memo, by the way. But the Sixth Circuit's basically telling the district court this is not good. And my expectation is the district court's going to defy the Sixth Circuit and issue the injunction anyway and wait to be slapped down. It's like, well, at least I did my part. Which I can understand. I can understand wanting to stick it to the Court of Appeals and be like, I'm not going to do this, you do it. I can understand that impetus. So, yeah. Equal protection. No state, the Fourth Amendment says, shall deny any person within its jurisdiction the equal protection law. Statutory classifications are ordinarily valid if they rationally relate to and further a legitimate interest. Yep, that's rational basis, right? Rationally related to and further a legitimate interest. More exacting scrutiny applies when law limits protected classes. Yeah, just any legitimate method for any legitimate purpose. So failing rational basis review is pretty hard, but it can be done. See example, gay marriage, where I think you banning gay marriage doesn't work because none of the arguments really work because you don't treat the straight marriages in a way that comports with your stated rationale. So it doesn't really work. It has to be rationally based, right? It has to be rational. So yeah. It's highly unlikely as an initial matter that plaintiffs could show the act lacks a rational basis. The state plainly has authority in truth responsibility to look after the health and safety of children. In this area of unfolding medical and policy debate, a state is rather than fewer options. Tennessee could rationally take the side of caution before permitting irreversible treatments. Hey, 333 people watching. The numbers increase. We're halfway to devil number. Yeah. The challengers pin their main claims for likelihood of success on the assumption that heightened scrutiny applies. They first argue Tennessee's act discriminates on the basis of sex. We're skeptical. The act banning gender affirming care for minors of both sexes. The ban applies to all minors regardless of biological birth with male or female organs. That prohibition does not prefer one sex to the detriment of another. The act mentions the word sex, true, but how could it not? That's the point of existing hormone treatments, to help a minor transition from one gender to another. That also explains why it bans procedures that administer cross-sex hormones, but not those that administer naturally occurring hormones. A cisgender girl cannot transition through the use of estrogen. Only testosterone will do that. A cisgender boy cannot transition through the use of testosterone. Only estrogen will do that. The reality that the drug's effects correspond to sex in these undesirable ways and that Tennessee regulates them does not require skeptical scrutiny. The regulation of medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext designed to effect an invidious discrimination, citing Dobbs and then citing Lundig. So yeah, the abortion is not discrimination on the basis of sex, is basically what that amounts to. No such pretext has been shown here. If a law restricting medical procedure that only applies to women does not trigger heightened scrutiny, as in Dobbs, A law's equal applicability to all minors, no matter how their sex at birth, does not require the scrutiny either. You want a harem? Well, good luck with that, I guess. The plaintiffs separately claim that the act amounts to transgender based discrimination, violating their rights as a quasi suspect class. But neither the Supreme Court nor this court has recognized transgender status as quasi suspect. Until that changes, rational basis review applies to transgender based classifications. In the context of preliminary injunctions and the need to establish a likelihood of success on the merits, that should be nearly dispositive given the requirement of showing a clear right to relief. The bar for recognizing a new quasi suspect class, moreover, is high. The Supreme Court has recognized just two such classes, gender and illegitimacy, and none in recent years. The court has not recognized any new constitutionally protected class in over 4 decades and instead repeatedly declined to do so. Holding mental disability is not a quasi suspect class, holding age is not a quasi suspect class, declined to address whether gay is a quasi suspect class. That hesitancy makes sense here. Gender identity and gender dysphoria pose vexing line drawing dilemmas for legislatures. Plenty of challenges spring to mind. Surgical changes versus hormone treatment, drugs versus counseling, one drug versus another, one age cutoff for minors versus another. Still more complex, what about sports, access to bathrooms, definitions of disability? And will we constitutionalize the FDA's approval process, even where accompanied by judicial tiers of scrutiny? The U.S. Constitution does not offer a principled way to judge each of these lines, and still others to boot. All that would happen is we would remove these trying policies from the 50 state legislatures to one Supreme Court. Instead of vigorous, sometimes frustrating arena of public debate and legislative action across the country, and instead of other options provided by 50 governors and 50 state courts, we look to one judiciary to sort it all out. That is not how constitutional democracy is supposed to work, or at least work best when confronting essential norms. So, yeah, let's not take this away from the legislature, just yet. Let's let the states do this. That makes sense. That makes sense with federalism. Bostock does not change the analysis. Title VII's prohibition on employment discrimination because of sex encompasses discrimination against persons who are transgender or gay. But the reasoning only applies to Title VII, as Bostock itself and our subsequent cases make clear. Yeah. So we got cases refusing to apply Bostock to age discrimination in employment, reasoning that Title VII's analysis does not apply to Title IX. See also Students for Fair Admission, which they cite a Westlaw site for. That's an interesting citation choice. I'm not sure why they did that, incidentally. Cite a Supreme Court case by a Westlaw site, but okay. Explaining that Title VI differs from an equal protection case. Smith versus City of Salem does not move the needle either. It was an employment case, involved an adult, and considered sex stereotyping, not whether someone's body was male or female. In that setting, it held a transgender employee fired for dressing as a woman, established a cognizable equal protection claim. It did not hold that every claim of transgender discrimination requires heightened scrutiny, least of all in the fraught context of whether a state may limit irreversible medical treatments to minors facing gender dysphoria. And Dobbs prevent us from extending Smith that far, as it held medical treatments that affect only one sex receive rational basis review. Kurt was a legacy student? No, no. Nope. My neither of my parents went to any of the schools that I went to. So no. We recognize that other courts and judges have taken different approaches to these issues. I don't have any lawyers in my entire extended family. I'm not sure, to the best of my knowledge. I don't know. Yeah, I don't have any lawyers anywhere in my family tree. It's the best of my knowledge. So not a lot of, yeah. We recognize too that several district courts have addressed similar laws in other states and addressed those laws in much the same way the district court did in this case. And our thoughtful colleague has reached a similar conclusion. We appreciate their perspectives, and that gives us pause, but they do not eliminate our doubts about the ultimate strength of challengers' claims for reasons just given. All told, the challengers lack a clear showing that they will succeed on the merits, and this is particularly so in view of the burdensome nature of facial attack and fraught task of justifying statewide relief. The other factors largely favor the state as well. If an injunction remains in place during appeal, Tennessee will suffer irreparable harm from its inability to enforce the will of the legislature, to further the public health considerations under guiding law, and avoid irreversible health risks. As far as harm to others, the Act's continuing care exemptions permit the challengers to continue their existing treatments until March the 31st of 2024. That feature of the law lessens the harm to those minors wishing to receive continuing treatment. But we appreciate it does not answer the concerns of those who might wish to continue treatment after that date, or those minors who might seek treatment for the first time in the future. That creates an irreversible problem of its own, one that lies in the context of this case. Both sides have the same fear, just in the opposite directions. One saying the procedure creates health risks that cannot be undone, the other saying absence of such procedures creates risks that cannot be undone. What makes it bearable to choose between these two sides is the realization that not every choice is for judges to make. In this instance, elected representatives made these precise cost benefit decisions and did not trigger any reasons for skeptical review in doing so. As for the public interest, Tennessee's interest in applying the law to residents and being permitted to protect its future weighs heavily in favor of the state. These initial views, we must acknowledge, are just that, initial. We may be wrong. It may be that the 1 week we had to resolve this motion does not suffice to see our own mistakes. In an effort to mitigate any potential harm from that possibility, we will expedite the appeal of the preliminary injunction with the goal of resolving it no later than September 30th. In the interim, the district order is stayed. So that's all good. All right, cool. Well, that brings us to the end of this decision, and it all sounds pretty good to me because these treatments are barbaric and untested and completely unexpected in every way. So I am not surprised that this decision has been issued, and I am actually a little surprised it's been issued, to be honest. I didn't think the Sixth Circuit would actually have the balls, but they had big balls. So I guess they haven't gotten the hormone blocker treatment yet, so that's nice. So all that stuff. And yeah, that pretty much brings us to the end of the stream. So let me see who's streaming and dump you over into someone else's stream as I get back to editing, which is I'm behind on. So let's see. Let's see who is streaming. Ah, that's nice. My last video was my most popular of the last 10. Supreme Court breaks new ground, a critical election update. Wow, that's really good. Wow. Yeah, number 1, 5.2 thousand views. Wow, average view rate 8 minutes. Yeah. Yeah. Yeah, we're done already. We just did the one thing today. We did a deep dive case today. So we just did the one thing today. Yeah, we're done. Karen, let's see. Karen hit $20 super chat. Bri K gifted 10 memberships. Susan Ferreira said, "Thank you, Kurt." Chouse became a member. Thank you for hitting the button. Pierre Delecto, 99 cent uncivilian. Lapsus 42, member for 13 months. Thank you. Soma Lama gifted 10 memberships. Thank you very, very much, Soma. Jules Buddha gifted 20 memberships. Alan Parker gifted 20 memberships, and John Doe became an uncivilian. Thank you very, very much. So yeah, I'm surprised that video did as well as it did. Yeah. Wow. Wow, damn, that video way overperformed. Wow. Views up 92%. Damn. Either I'm getting better at my job or something. Damn shit. That is very good news. I'm very pleased. Maybe all my efforts in terms of like title selection and stuff are going really well. It's like the most basic thumbnail too, which is also surprising. I'm not sure what that says about anything. Maybe all my complicated thumbnails were not helpful. All right, let's see. Let's see. Let's send you guys to Legal Vices. He did me a solid of giving me a redirect recently, so I want to give him a payback. So let's send you over to Legal Vices so you can say hi to his chat as he streams the FL versus YNW Melly murder trial. And I work on my editing that I need to do. So that's fun. We will be on tomorrow, probably with regular legal news roundup. We will do that. And until later, my friends, I hope all is well. Cheers, my friends, and goodbye.